If you want to avoid ruining your retirement, this video is for you. You could be doing everything right with your retirement, save, invest, do your estate plan, everything, and still ruin your finances and run your retirement ship aground if you overlook this tiny detail. Now, what I'm talking about is making the mistake of not granting a power of attorney on your retirement accounts to someone you trust. Fortunately, there is a very simple solution to this problem, and if you stick around to the end of the video, you'll know exactly what you need to do to protect yourself from this threat. I just want to point out that I'm not an attorney, and the information I'm providing here is for educational purposes only. You should consult your own financial and legal advisor for the best course of action for your particular situation. First, what's the problem? Well, the issue is if you become incapacitated, you may not be able to sign your name. And if you can't sign your name, you can't do business. And if you can't do business, among other things, it may mean you won't be able to access money from your retirement accounts. Now, if you depend on that money at the time of your incapacitation, that means you're in trouble. That's because usually you have to sign a distribution form in order to make withdrawals from those retirement accounts. You might be thinking, hey Neil, I've got beneficiaries all set up on my IRAs and my 401ks. I don't have anything to worry about. Well, if you die, you're right. Your beneficiaries will inherit your retirement accounts when you die, and they'll be able to access all your retirement money. They won't have anything to worry about. But again, that's if you die. What if you don't die? What if you become incapacitated, as I said? What if you become incapacitated before you die and you and your family rely on your retirement assets to create retirement income? Well, if you can't sign your name and you need access to those retirement assets, nobody can get that money for you, not even your beneficiaries. That's because you're still alive and your beneficiaries have no legal standing. So how do you access money from your retirement accounts if you can't sign your name? Well, the answer is you can have someone you trust do it for you if you give them the power to do so by setting up a proper power of attorney before you become incapacitated. That's because the power of attorney documents bestow the power to act in your place to a specific person or persons, even if you're incapacitated. Now, we'll get deeper into this in a minute, but before we do, let's examine the facts. According to the United Nations Department of Economic and Social Affairs Department, 46% of those people over 60 years of age have disabilities, and 3 out of 4 of those people have moderate to severe disabilities. Looking at this another way, according to the CDC, 2 in 5 adults aged 65 or older have a disability. That's 40%. Now, that doesn't mean that every disabled person is not going to be able to sign their own name, but are you willing to take the chance that you'll beat the odds? Isn't it better to plan for the worst and hope for the best? Of course it is. You might be thinking, hey, wait a minute, I did my estate plan and I created powers of attorney in my trust documents. Well, if that's true, you might be okay if the company where you hold your retirement funds, like Fidelity, Vanguard, Schwab, Pershing, etc., accept those documents. They may not like the wording of the documents and they might reject them. The problem is it may be difficult to ascertain that now. And the last thing you want is to find out after you're unable to sign your name that the documents you prepared aren't going to be accepted by your brokerage firm. Again, there's a solution which we'll get to, so please be patient. Now, why don't advisors ever talk about this? Well, for most advisors, this is beyond their training or concern. In other words, their focus is on your investments, and they don't view it as part of their job to give you important financial advice beyond that limited focus and scope. The next question, are all powers of attorney documents the same? No, and this is where I have to insist that you speak with your lawyer to make sure that you proceed appropriately. By the way, we'll talk about how to find the right legal advisor in future videos, so please subscribe to our channel and smash that notification bell so you're notified when we release that and future videos. Some powers of attorney are durable and others are not. Durable powers of attorney stay in force until you specifically nullify them. Non-durable powers of attorney expire at some point or after something happens. Now, since we're talking about having these in place after you become disabled, we're really talking about durable powers of attorney. That's what's important. Now, some powers of attorney are what's called springing powers of attorney, and others are not. Springing powers of attorney only take effect once something happens, like you become disabled. Now, many lawyers like to write up springing powers of attorney when they prepare your trust documents. Why? Well, this way, while you're capable, nobody has access to your money, but if you become disabled, the power of attorney springs into effect. That's smart. But the problem is, the bank and brokerage firms may only allow you to submit those springing powers of attorney once those conditions take place. And at that point, of course, they might reject your documents for a variety of possible reasons. The problem is you'll be in no condition to do anything about it if that happens. Compromise option. One idea that your advisor may suggest is to grant your spouse or some other trusted person what's called trading authority on your account. This will give them the power to buy, sell, deposit, and withdraw money on your behalf. And it sounds pretty good, but there's a couple of big problems with this. First, as I said before, once you grant this trading authority to another person, they have the power on your account immediately. So you have to be darn sure you give that power to the right person. Another big problem is that this trading authority may not grant the person the ability to sign a distribution form. And that's the form you need to be signed if you want to make withdrawals from your retirement account. In other words, the trading authority may be a solution for non-retirement accounts, but depending on the bank or brokerage that you're working with, it may not work with retirement accounts. So what should you do now? This issue is really important if you want to make sure that you and your spouse still have access to your retirement funds even if you become disabled. Now, I know this all sounds a little complicated. It doesn't have to be. Just follow the following simple steps one at a time to make sure that you'll be safe. First, talk to your attorney and get their advice. If they've created powers of attorney documents for you, they might suggest that you submit them to the brokerage and bank now and try to get those institutions to tell you if they're going to accept them or not. Second, even if your power of attorney documents are springing power of attorney, you can ask the institution to review them and determine if they're going to accept them or not. They may or may not agree to review the documents, but it's certainly worth asking. Third, if you don't have power of attorney documents set up and your attorney doesn't recommend doing so, ask the attorney if they encourage you to use your bank or brokerage firm's power of attorney documents. If the attorney is okay with it, get the bank and brokerage to send you their power of attorney documents, fill them out, get them notarized if required, and submit them. Note, you'll need to do this for each bank and brokerage firm that you do business with, and possibly you'll need to prepare documents for each retirement account you have. 4. Even if you have your power of attorney documents, you may want to also fill out the bank and brokerage forms. Talk to your attorney about that. If you do that, you know with 100% certainty that they will accept them, as opposed to your attorney's documents, which may be great, but the bank and brokerage may reject them anyway. Are there any risks to using the documents the bank or brokerage firm provides? Sure. First of all, the documents supplied by your bank and brokerage are only valid for that particular institution, like I just said. So if you get documents from Bank of America, for example, they won't be honored at Vanguard. As I said, you'll have to complete and submit, and in most cases notarize, documents from each of these financial institutions that you work with. Also, and this is a big issue, the power of attorney documents that your financial institution supplies aren't springing powers of attorney. And what that means, and this is super important, once you sign and notarize and submit those documents, the person that you've designated as your power of attorney will have power on your account immediately. Now, at the end of the day, you have to weigh the risks and make your best choice. It's individual. You may be in a situation where it makes most sense to do nothing. Or it may make sense to use your bank and brokerage documents to create the power of attorney because you know that they will honor them. Or it may make sense to just rely on the estate planning documents that your attorney created. It depends on your family and financial institution, and it's certainly something worth discussing with your own legal advisor, and it's worth the money to do so. The good news is now you can discuss these issues with them from a highly informed state, and you can ask the questions that make sense. For more videos that empower you to have a more secure retirement future, please subscribe and smash the notify bell so you'll know when new videos are released. Also, if you have any questions, just leave them below. We look forward to answering them and connecting with you, and I look forward to seeing you in the future.